The Karnataka High Court has delivered a significant and far-reaching judgment that clearly protects the rights of employees across the state. The court has ruled that employers have no authority to investigate or verify the caste certificates of their employees. That's a good news. This important order was passed by Justice M. Nagaprasanna of the Dharwad bench of the Karnataka High Court while hearing a petition filed by a fire station officer from coastal Karnataka. What the court said? The court clarified that only the District Caste Verification Committee has the legal power to verify the caste status of any individual. Employers, departments or institutions cannot conduct inquiries into caste certificates on their own. The court observed that caste verification falls strictly under the Karnataka Scheduled Caste, Scheduled Tribes and other backward classes, which is Reservation for Appointments, etc. Act, which is 1990, and no employer has jurisdiction beyond this law. The petitioner Raju Talwar was appointed as a fire station officer under the other backward classes, that is OBC category, as the Talwar caste was listed under OBC at the time of his appointment. However, on March 20, 2020, the Scheduled Tribes order was amended and the Talwar caste was included in the Scheduled Tribes list. Later on October 29, 2022, the Karnataka government removed the Talwar caste from the backward class reservation list. Following these changes, Raju Talwar claimed his status under the Scheduled Caste category and was promoted according to existing reservation laws. On January 29, 2025, the regional fire officer issued a notice to Raju Talwar asking him to appear for an inquiry into his caste status, questioning how his caste category has changed after his appointment. Challenging this notice, Raju Talwar approached the Karnataka High Court, arguing that his employer had no legal authority to inquire whether he belonged to a scheduled caste or a scheduled tribe. The court agreed with the petitioner and made its position very clear. Justice M. Nagaprasanna stated that it is clear that the employer does not have the authority to inquire into the caste status of employees. This responsibility lies solely within the District Caste Verification Committee. This is a settled principle of law upheld by several judgments. The court further held that since the employer lacked authority, the notice issued to the employee was legally invalid and the petition deserved to succeed on this ground alone. This ruling is being seen as a major relief for employees, especially those working in government and public sector institutions. It ensures that employees are protected from unnecessary harassment or departmental inquiries related to caste status. The judgment reinforces that caste verification is a sensitive legal process and must be handled only by designated authorities, not by employers. With this verdict, the Karnataka High Court has drawn a clear boundary. Employers can appoint and promote, but they cannot investigate. This decision strengthens the rule of law and safeguards employee rights. Make it clear that caste inquiries must be conducted only by the District Caste Verification Committee as prescribed by the law.